So we're talking about legal practice as a business practice today, as a business process today, re-envisioning legal practice as a business process. So last week we talked a little bit about case management and some of the general technologies that are used in law firms today. And we spent actually quite some time talking about some of the mental barriers that lawyers have in adopting new technologies, and some of the institutional challenges that technology and legal tech entrepreneurs are facing, trying to sell into law firms, big or small law firms. And today we'll be really focusing in on the business process of law, and we'll hear from some of the country's leading innovators who are experienced lawyers and who realize that there are better ways for delivering their services, and they came up with new ways in kind of disaggregating what they've been doing and coming up with new workflows and some new ways of interspersing technology in the delivery of their legal services. And so our first speaker today will be Richard Granite. He's a lawyer and a recognized expert on the delivery of legal services over the internet. He's also the co-chair of the e-lawyering task force, so he's not only a lawyer and an entrepreneur, but also somebody who's trying to change our institutions to facilitate the delivery of legal services online. And he's has so many awards and recognitions that it's really hey Deborah, please grab some space. Very accomplished legal tech entrepreneur and recognized by the ABA. He won their Lifetime Achievement Award, sort of recognizing all his innovations in the delivery of legal services. He's also been, over the last 30 years, really, he's carried different hats that allow him to, kind of make some inroads on the delivery of legal services from. So he was first in the working group in a working group that created the National Legal Services Program. He also served as the director for the Center for the Legal Studies at Antioch Law School, and he was later the president and dean of Philadelphia's Institute for Paralegal Training. He's also a founder of really one of the first legal tech companies called Automated Legal Systems, which really was sort of one of the first companies using computers in a legal context. He's also on the speaking circuit, and he's been speaking at a lot of conferences and law schools, and he's a graduate of Columbia Law School and the University of Pennsylvania, as well as Lehigh University. So our commentator today will be Richard Sapien, actually. So he'll be asking the first couple of questions regarding the presentation. So without further ado, I'll turn it over to Richard.
Thank you. Before I get started, this is going to be like a kind of crash course in what's really happening in the legal profession in terms of changes, and kind of a description of what's happening as the internet becomes the primary platform for the delivery of legal services from face to face. People don't realize that the internet is now becoming the platform for the delivery of legal services rather than in office. And when a platform changes, those who are in are out, and those who are out are in if they really understand how to do that. So we're going through this major paradigm shift. Many lawyers don't get it yet. I know this because I run a company which provides a virtual law firm platform to solos and small firms, and I see when I deal with these, frankly, slightly older lawyers, they simply don't get it. My own interest has always been access to justice, trying to really penetrate the 85% of Americans who can't afford a lawyer, what we call the large latent market. And even though I also went to an Ivy League school, I went in another direction. I never worked for a big law firm, and I'm proud of it. And everything that I've done is to try and figure out a way to make law accessible to people, because if we really can't do that, then there's something really wrong with our legal system and our profession. So what I'm going to do today, I'm going to go through a set of issues and give you a little bit of a paradigm of what's happening in the changes in law. So when you go to work for a major law firm, it's what we call a solution shop model, where every problem is designed to be analyzed as if it were indeterminate. This is what we're trained for in law school. All lawyers are trained, no matter what size of firm, no matter how complex or how simple the problem, to function in what we call a solution shop environment, which is always characterized by fee for service, usually on an hourly basis. It assumes that legal problems are indeterminate, are complex, and we need to solve them intuitively. And the major resource for that is really people, and highly skilled people. It's what actually you're trained for in this law school. But the reality is 85% of other law schools who are producing graduates who end up in solo and small practice, where they're dealing with relatively routine problems and standardized problems, need other sets of skills in order to really deliver legal services economically and affordably. And ironically, we'll see that even in the large, big law firms, there's now a shift in the demand for a different business model being driven by large general counsel. I'll show you what I mean by that. The second model is what we call evaluated process model. An evaluated process model, you take people, software, skills, procedures, checklists, and you put it all together, and you produce something which is evaluated fixed price legal service. Not based on a time basis, it's usually based on a price that's related to the value that you're contributing. And we see this on the lower end of the spectrum in solos and small firms when we deliver what we call limited legal services or unbundled legal services, which are things like LegalZoom does for a fixed price. You know, LegalZoom is not a law firm. But what's interesting is that corporate legal departments are now demanding of their large law firms that things that are more standardized be delivered with the process model rather than the job shop model. So this is creating lots of confusion among the large law firms because they're tooled up to deliver what we call this solution approach, which requires highly skilled folks. And when you go backwards and you take a look at these kinds of organizations, which are process-oriented organizations like Mayo Clinic and Four Seasons and Safehearth, which is a big law firm in Chicago, all these organizations have developed process methods for producing the same quality of service every time that it's offered, and producing a standardized result which they can actually offer at a fixed price. So these are the commonalities between all these organizations. You get the same quality every time. You get feedback loops, which is constantly evaluating what's really being delivered. The lawyers in this case, and I'll show you, have an understanding of how to deliver legal services at a fixed price rather than an hourly basis. And you have a culture of innovation. Many large law firms have still not adopted this approach, and it's causing tremendous confusion because they're designed to deliver a problem-solution approach, but the general counsel of the large companies really want something which is process-oriented at much less cost for things that are more standardized. Another way of thinking about this, if you have a big general hospital, which has a huge overhead, and then that results in very high costs. But then you see things that get spun off, like the ambulatory surgery center or the Minute Clinic. These other pieces of the standardized delivery of health services result in much lower overhead, much more consumer-oriented. So the large mega law firm is like the big hospital with a mixed business model which they haven't yet sorted out yet. They're just beginning to sort it out. A firm like Safehearth has created what we call a global innovation group, where they are purposely on transactions which are complex but which can be standardized, figuring out ways to deliver those legal services at 40% of the cost of what their competitors are now choosing. So of course, once you have one or two major firms begin to move in this direction, it's going to force competition and modeling by other major big law firms. So I believe that we have this confusion of business models, and it requires actually new skills and maybe new entities and new approaches. And we'll talk about that in a few minutes. So here's an example. Axiom Law. Whoever has heard of Axiom Law? Anybody here? I know you have, but so Axiom Law is not a law firm. It's an outsourcing firm. What they do is they just do those standardized transactions working directly with the general counsel, and they bypass and compete against big law firms. Because they're not a law firm, they've been able to raise some significant amounts of capital and therefore innovate on the technology and management side. They're up to 1,000 lawyers, and they work directly. There's a trick here. They work directly with general counsel. They can't offer their services directly to the public, right? Because they're not a law firm, but they are delivering a legal service. The rules are that if you're a general counsel and you take responsibility for the legal service, you're considered to be a supervising attorney. Meanwhile, they're up to $60, $70 million in revenue. They just did another 20 million capital raise. And so their market share is expanding. It's probably more than, it's probably 120 million. Their market share is expanding at the cost of big law. There's another example. I know you know Andy Dawes, right? Is he going to be here tomorrow? Maybe?
Yeah, I think so, yeah.
Yeah, so if you go to ripreviewlaw.com, there's a really good video about their approach. It's a UK-based firm now trying to expand to the US. This is a true law firm. Everything they do is fixed price. No matter how complex it is, it's fixed price. They started the firm 3 years ago. D.L. Piper is actually a backer of the firm. They're up to 100 million in revenue. I mean, it's incredible. And the amount of market share that they're eating, because they know that customers, clients, really want this kind of fixed price approach. This is, you know, when we talk about, this should not be new to you about what's going on. I don't know if you studied Susskind in the class, but we know that legal services are evolving into a continuum, and those that become standardized and digitized become more commoditized. Once they become more commoditized, they get reduced in price. Therefore, you need other kinds of suppliers to do that. Either that, or you need to have a large law firm that innovates by creating some other kind of unit that can offer a lower price service without really undercutting the core higher price problem solving services that the major partners offer. You know, we talk about DUI law, that's like another whole class in itself. I mean, I don't know, unless you've been sleeping, you know, like LegalZoom today is the biggest brand in America. They'll do 180 million this year at the expense of solos and small firms. And they just provide a solution that's good enough. No legal advice, but we know that a digital solution can solve the legal problems of some folks. And we know that people will opt for that because it's price accessible. And LegalZoom is only one of dozens of competitors, including stuff that we do. I mean, we tell a healthy business tapping into this latent legal market because we know that there's really demand there. But the concept of DUI law really applies even in large corporate work when you combine technology with management and service and process. So for example, if I'm an employment lawyer and I have a Fortune 500 client, the HR counsel, general counsel, rather than have them call me with every kind of legal piece of question and legal advice, and that general counsel has to be the support of the HR managers who are hiring and generating NDAs and independent contractors for all of their people that they deal with through the HR department. I would be better off developing a set of systems, which I license to that Fortune 500 company, so that the more routine transactions like generating NDAs, employment agreements, demand letters, can be done internally, DUI, by that company with a trap door, so that when it's complex, they come back to me for legal advice. If I can show that Fortune 500 company that I've developed a system that it's much less costly for them to buy into than any other Fortune 5 big law firm, I have a competitive advantage against my other competition. So those kinds of approaches that I just described, not yet. Believe it or not, that strategy is not developed yet, but it will come. It will come. So when you move into process engineering and you want to apply the skills of what we call lean law to develop new systems, you begin to borrow the techniques and the skills essentially from Sigma 6, and for those of you in business school, process engineering techniques, and other sets of skills so that you can figure out what legal services actually cost, So what we mean by lean law is delivering more for less. This is the important thing, obviously, right? Everybody wants more for less. They would like legal services for free. That's not going to happen, but the constant trend is more for less. Other than when you have a case when you're betting the future of your whole company, then you don't care, and then you're going to pay a premium rate, and then you're in the problem-solution part of the business. But once you're out of the problem-solution part of the business and you're dealing with routine transaction, everybody wants more for less. And you have to figure out ways to add value in that context. It's no more like just cut and pasting a document in a complex document and keep on billing hours and hours and hours when you know you can get from somebody else the same legal product at a third of the price. So how are you going to make money if it's a third of the price? You have to begin to employ what we call software-powered services. So human services assisted by software, which increases productivity and not only increases productivity, but it actually increases profit margins when it's done correctly. We run a course in legal project management. The other thing you didn't say what I'm doing is developing a series of courses nationwide on a distance learning platform for law students in these skill sets: legal project management, legal document automation, legal expert systems, process engineering, offered by some of the leaders in this space, because we believe that law students should know more than doctrinal law. If you're going to be successful in your career, even if you're going to go into a solo practice or a big law firm, these are other job titles that really will enhance your career in the future. So how many people have read Susskind's book, Tomorrow's Lawyer?
So,
You
yeah,
have,
we
right?
had some chapters assigned.
Okay,
to
so
for
Tomorrow's Lawyer is
classes.
a very quick read. It's by Richard Susskind, who is probably our thought leader, and he's going to speak tomorrow at the Future Law Conference. You're beaming him in, right?
We're beaming him in, yeah.
And so I'll probably talk about this. And Richard's a guy I actually know, and I kind of discovered him, and he became a mentor for me a long time ago. And I've kind of borrowed his ideas. I'm an implementer. He's really a thinker. And so a lot of the work that I've done has implemented his ideas in my commercial ventures and my other ventures. But the latest thing that I'm kind of borrowing and stealing from him, which he knows about, is I took his book, Tomorrow's Lawyer, where he talked about all the new job titles and skills that we're going to need in the future. And I'm converting that into an online distance learning curriculum. Because each one of these competencies will actually be a job title in a large law firm or a corporation or an outsourcing company. A job title like legal document specialist, knowledge engineer. That's not going to be for everybody, but certain people who have those kind of inkling to do that kind of work, we're going to see huge demand. And you know, certainly this is Richard's projection, and he, in the fullness of time, he's proved to be right. Put it that way. So let me just move this. So the concept here, just in terms of legal services, is to try and figure out how to streamline things, how to add software that automates part of the process. Once you add software, once you change overhead basis, you basically re-engineer every little piece of what it takes to deliver and produce a legal service. So this is our piece from project management. So this is actually out of the course that we're doing. You know, lawyers, you're not going to law school to become project managers, but the reality is, if you're running a department in a large law firm, you're a project manager, and you need to know something about project management skills. You need to know how to estimate the cost of what it's going to be for your client. You need to know how to figure out how you can produce things on time, and there's a whole technology to that. It's a project management technology. It's not really rocket science. And I suppose you're going to have somebody who just is devoted to that, but the reality is, if you're a senior lawyer and you're managing workflow, you're going to be a project manager. So the purpose of all this is to get a better idea of how to manage costs, because this new normal means that at every juncture, the GCs of large corporations are going to ask the questions, are you giving me the best value for my dollar? Sure, I understand I'm going to have to pay $1,000 an hour if I'm betting my company on a huge litigation. But even in that environment, we know there can be litigation savings if it's done right. But if it's a more routine piece, they're going to, the GCs are becoming purchasing agents with all of the purchasing agent technology that's required. So that causes a change in professional behavior. It's not enough just to know what the law is, to be able to do legal research, to have negotiation and advocacy skills. To be effective, you have to have, in our view, a slice of these management technologies to be able to thrive in this new normal environment. I have lawyers saying they can't describe what the legal outcome is going to be. We can't predict what the cost is. It's too complicated. It's too difficult to project. That's not going to be an adequate answer in the future. So if you think about, I built a house a couple of years ago. I had a fixed price contract for, 7 figures. And the guy went over that project, paid a penalty or he had to eat it. It's complicated to build a house. It can't be that much more complicated than running a major piece of legal work. And of course, anything outside of the legal environment has all sorts of tools in terms of managing costs, managing deadlines, managing time. But these disciplines have not really permeated big law and small law, actually. And big law know what they're doing, basically. That's the reality. We had an environment where the lawyers were simply incentivized to bill as much as they could. It was a cost-plus environment. Those days are now gone. They've been gone since the recession. That's why employment is flat. That's why organizations are law firms are trying to figure other ways, big law firms, to create entities which are streamlined in areas like litigation support, where they can lower their cost base and lower their environment. All right, so I'm going to move on for a minute. By the way, this is a new application, a company that I'm dealing with called lawpal.com, who's backed by a lecturer is here, backed by Peter Thiel. And this company is developing an application so that any lawyer can go create an environment to deal with their clients and easily create a project management plan without knowing anything about project management. Basically, it's an embedded software application. It's worthwhile looking at it. It's a trial. Go to lawpal.com. It's easy to remember from PayPal. It's easy to that. So this is like his new thing. He wants to kind of disrupt the legal industry now that he's disrupt the payment industry. Hopefully the things will come out of that. All right, so these are the technologies that you begin to use in sorting out new legal services, process maps, metrics. I'm speeding through this. All leading to fixed-fee practice. The outcome of this is to create systems of people, including legal assistants, non-lawyers, supervising lawyers, where you can begin to work at the top of your license. Ideally, you should be able to delegate to either junior lawyers, paralegals, or other staff, or technology, those tasks which are amenable to automation and systemization, so that you can work at the top of your license, which is the problem solution stuff, where you can really work on the analytics, where you can really work on dealing with subtle, indeterminate problems, which is what you're really trained to do. Now, that's not going to be reality. Not everybody can do that. Not everybody's good enough to do that. Doesn't mean you can't make a living doing all sorts of other things at different levels and in different, what I call essentially different career paths. I mean, even today, we know that people go to big law, only 1 out of, 20 become partner, and the rest of them float out to other law firms. They set up their own law firms, so that's another skill set. Rich? Okay, got it.
So one of the readings we assigned for this class was the Bill Henderson article in which he talks about Larry Ripstein's piece on the death of big law.
He does, so I think he's a little bit extreme on that, but he talks about that. And what he's done is he's measured the real employment. He said the employment growth in big law has been flat, and the real growth is what we call other legal organizations, which might be outsourcing organizations, discovery organizations, branches of law firms. You're right about part of that.
Right. And then a lot of big law firms are over-leveraged, and what I hear you say is, there's not a whole lot of innovation in big law happening, and we sort of singled out Cypher. Shaw's is like the one firm that is like going to Six Sigma. Right. Lean Six Sigma processes and also this interesting implementing change kind of case study, how they deployed these kind of champions within the firms and so on.
That's unusual.
And they've been using it I mean, that's like forefront of their marketing. Like,
Right.
first thing you see on their website is the chairman talking in the New York Times about it. I've sort of heard, you know, and they hired legal solution architect, which is what Suskin's talking about, is
Right.
one of the new professions in the future,
Right.
and which is what other, you know, we feel, you know, it seems like, you know, there's a lot of opportunity there. I've heard sort of through the grapevine that there's like some pushback within cyber law, and it's not a completely clear success story yet.
It's not a complete success story yet, but it's definitely achieving certain wins for the firm. There's no question about that. But I think these patents, the patents of change get executed in many different ways, which actually create different kinds of entrepreneurial opportunities for lawyers. So you're going to hear from Raj. He's going to talk about, I don't know what he's talking about, but he could talk about Trademarkia, which is a process-oriented company, right, that has taken a niche, trademarks, and in the span of a few years, it's the largest trademark site on the web. And now we started out with people who were underserved, like small business, but he's moved up the value chain to serve bigger and bigger companies with a value-added proposition. So you're going to see spin-offs of companies like that, which are process-oriented companies, which compete against big law. You're going to see other varieties of alternative dispute settle mechanisms also, because people are fed up with the courts. So Marion Sophia runs a company called FedOr with her husband, which creates a private judicial system at a lower cost and a faster result than you would get by going to the court system. So in every area, you're going to see large firms innovating and creating their own subsidiaries where they can innovate. You're going to find other things that compete against them, like specialized niche companies that provide software or provide a platform, which you'll hear from Alma talk about litigation support, right, as an outsourced platform for litigation support. That's a good segue to this concept of virtual lawyering, so I'm going to shift for a minute. So one of the things that we do through Direct Law, and you can go there and you can see it, directlaw.com, you can sign up for the trial, you can see what a virtual law firm actually looks like in terms of actual, what I call utility. You don't need a credit card to sign up, and you can just sign up as if you were a lawyer. So what do we mean by a virtual law firm? 95% of law firm websites are passive websites. They're not interactive. You can't relate to your clients online. In order to relate to your clients online, you have to have a secure client portal. There's not magic about a secure client portal. When you sign up to Bank of America or Charles Schwab or Expedia, you're in a secure client space. That's your own particular client space. The legal profession is further behind every service industry in providing a secure client portal to their clients because they're technology challenged and they were concerned about security and the security and the propriety and the confidentiality of data. But those problems have actually not only gone away, but we have now a beginning slope of law firms adopting the secure client portal concept. And I think we distributed the paper that we just wrote, which Stephanie can run myself, or the things I sent you later, to give you a kind of an idea of the history of that. But you can't relate to your clients online unless there's a username login. It's really related to the architecture of your website. There has to be another space that the client can actually sign into. And within that space, you then can do all sorts of other things. You can help the client create documents, you can do collaboration, you can do communication. And I believe that even though this movement starts with solos and small firms because they're early adopters and they can make decisions quicker, it's going to scale all the way up. So the large firms are going to begin to hollow out as well. And they'll also provide client portals for their clients to work in. So sometimes we hear, people tell me they're a virtual lawyer because they work at home in their pajamas and they meet a client at Starbucks. That's not what we mean by a virtual law firm. That's just an untethered lawyer who's mobile. But that lawyer can't really work with their client securely in an ethically compliant space unless there's a secure client portal that's supported by somebody with bank-grade security. These are software services provided by a third party because every individual law firm can afford to develop the particular technologies that are really being brought to bear. So the law firm, whatever size, then contracts out this, the capacity to provide these tasks through an independent platform, which they can now access at a very low price. 10 years ago, we couldn't create these technologies and deliver them for lawyers. I'm talking about for a solo $200 a month or $100 a month. So there's no reason why they can't adapt. I mean, we have a millennium generation. It's your generation. When you get slightly older, you'll have legal problems. You aren't going to expect to deal with your lawyers online. In fact, many don't want to talk to them. You probably really want to text them. But most lawyers today think that you want to come down to their office and sit there and talk to them and give up a day of work. There's a real disconnect between the existing lawyer behavior and what we know consumers actually want. Go ahead.
Well, I understand what you're saying about the idea that you want to have a secure website to the client, but and the fact that law firms might need to provide those services, but lawyers usually will also want to have the higher demand that usually most web servers wouldn't want, that is legal signatures or digital signatures, because they need the verification to know that the person that logged into the service is their actual client, and that demands much more security than what the market usually offers.
Anybody who's in this market is a specialized vendor. They only house their services in a bank-grade hosting service. There are procedures that are in place that enable you not only to identify your client, but to do a conflict of interest check and to make sure that you're not serving a client who's not in your jurisdiction, which you wouldn't be eligible to serve. So the software basically builds in all those checks and balances. These are some of the things that you can really do inside a client portal. And that's only a kind of a limited list. There's more to do that. Did this just shift by itself? We believe, I mean, these are what the numbers look like. This is a generation that grows up with their internet in their DNA. I mean, it's because it's the internet natives. We're just, some of us are just internet, immigrants or something like that. So we have a huge, this generation is huge, 75 million US population that has expectations because they shop online, entertain online, play online. It's huge. Basically, and the profession's not really responding to this fast enough. But in the fullness of time, I believe they will. This latent market concept is another set of issues. We estimate it's like 45 billion. It's everybody who doesn't use a lawyer, who can't afford a lawyer, to the extent that you can be creative, and I'm not going to go through all that, but be creative and you can figure out a way to tap into that, you can make a lot of money. You can make a lot of money because the market is so huge. You have to charge less per event, but if you figure out ways to deliver these services in a way that's software mediated, here's some examples, but you can make as much as billing by the hour, put it that way. This software is very powerful in terms of increasing profit margins.
Can you a little bit elaborate on your point that only 20% of the consumers use?
What was the point again?
What are the reasons behind that?
Which one?
Can you go to the previous slide, when 20% of the consumers access legal?
Yeah.
What are the reasons for so few numbers?
Well, one of it is price. One of it is engagement. One of it is they don't know they have a legal problem. We have good ABA research on this. It's not always price. It's people don't understand when they have a legal problem. That, it's too difficult. It's too inconvenient. They're afraid of dealing with a lawyer. They don't trust a lawyer. There are multiple reasons. There's a huge gap. These are even people who can afford a lawyer, much less the people who can't afford normal fees. The challenge is to figure out a way to dig deeper into the market. The example that I use often is the example of Southwest Airlines. When Southwest Airlines started, they targeted bus passengers, not other airline passengers. And they came up with an approach that was really very affordable, and from a price point of view, with a set of procedures and a value proposition that really attracted bus passengers. It's now the largest airline in America. So just once they got a foothold, and from a price value point of view, they just went up the value scale. So true innovation happens that way. LegalZoom is actually a true innovation. I mean, they're doing a couple $100 million a year. They start out with what we call a good enough solution. Good enough solution gets a person's legal problem solved maybe not perfectly, but good enough to get the job done without really having a lawyer involved. That's a good example of that. We do some of that also in different niches, so I've seen the power of it. But you can, that concept, I think you can also apply to large firms as well. You know, the framework of innovation and disruptive innovation and figuring out ways to serve people who are not served is a powerful set of business propositions, I think. Here's an example. I think this is a good example, actually. So we have new crowdfunding legislation that's going to be in place probably by August or September of this year. This is the new crowdfunding legislation. It changes the rules on private placements, but you still have to produce a private placement memorandum. SafeAuth, working with Neota Logic, which is a legal expert systems platform, has created an expert intelligence system so that you can answer a bunch of questions and create your own private placement memorandum. Still need a lawyer involved, and it'll do 85% of the work. So it's a major innovation because normally the lawyer's going to charge 20 grand for a private placement memorandum. With this technology in place, maybe 5, because the lawyer's just going to do the review at the end and make sure there are no loopholes in it. So that's just one little example of the kind of innovation that happens when you combine software, people, and even lower cost people, like combinations of paralegals and lawyers, or legal assistants and lawyers. That's what system design really does, and creates a new legal service. What we have in America, among solos and small firms, is hundreds of thousands of mom and pop operations with no systematic technology, no sense of quality control. I mean, reality is you go to a lawyer, you get all kinds of quality coming back, no systemization. One of the reasons that we don't have major systems, it's another subject, is that you can't invest in a law firm because of 5.4. In England, we've had deregulation. The experience is proving to be very interesting and positive. We have 300 alternative business structures in the UK. We're getting, the reason for deregulation in the UK was the access to justice problem, to try and crack the monopoly of the legal profession. This seems to be working. So in the fullness of time, I think that's going to come here as well. So that we'll have Walmart running a law firm. Go ahead, Tom. Much of the time. So who's the commentator?
It's Richard, actually, but
Okay.
I was ask you a question.
Yeah. So it seems like it's hard to establish trust between like lawyers and clients on the internet.
It's hard to what?
Establish trust.
It's not so much establish trust. Trust can be a function of the information and the content on the website. There are indications of the way in which you design your website and the content and your credentials that it's a key website design factor to establish trust. If your website is crappy and it has a lot of the wrong stuff on it, there is no trust. But there's enough evidence. We know we have run commercial ventures. I spend with thousands of clients a month.
Yeah.
So that's evidence of trust. It doesn't hold for the spectrum of clients. Obviously, there's always going to be
Different cases.
Right. There can be a demographic that's not ready for this yet, but they're going to die. That's what happens. That's what happens. That's what happens. And the lawyers that I deal with, they say to me, "Well, I'm still having my secretary, read my email to me." I said, "You should retire, Then I go to trade shows, and they walk by my booth and they don't get it. I say, "You should retire." Okay, so how about I'm trying to watch the time because we should.
Richard,
thanks. I'll just ask one question then. So we're talking about disruption. It seems like a lot of what we talk about revolves around price structures or making work more efficient. Can you give maybe examples how there's disruption in final product or outcomes, or are we still producing the same memo and deal documents, or who's making work for the better?
No, the outcome may be similar. The outcome definitely is similar, but the price is less. The major variable is price, and maybe also in customer service, and the way in which the customer perceives that the service is delivered. That's an external factor to the core work product. The work product, that's the point. The work product is really the same. So if I'm doing which I'm doing now actually, a 355 split off, which is a complicated tax transaction, but it's not so complicated. It's like 4 standardized documents. If I get those 4 standardized documents, I have an IRS compliant transaction. I have to use that as an example because I've been shopping around for a lawyer to do it. They give me prices anywhere from $5,000 to $30,000. And it's not rocket science. I mean, I have to be a lawyer, so I understand what the rules are, but it's not rocket science. And the point is that the output is really the same, but the prices are much less. Even in litigation, you know, in routine litigation, like PI litigation, where a law firm is defending a large insurance company, and they have a retainer to handle 100,000 cases, they price that not on an hourly basis. They give them a fixed price because they understand their cost structure sufficiently so they can defend all those cases and advertise the cost over a set of probabilities. They have enough experience to know what it costs to manage those cases. So the point is the outcomes are the same, whatever it is. You know, getting a result, whether it's litigation or getting the transaction done. But the price is like 60% of what it used to be, and it's controllable. If it's fixed price, it means the client is not controlled over the price, so risk is now shifted. You don't control risk if it's only on an hourly basis. 20 years ago, or 15 years ago, I tried to make a presentation on document automation in a large firm. And I tried to explain how much time they were going to save. A partner said to me, "Why do I want to save time?" What? I mean, no other industry sector really operates this way, with this kind of arrogance. And you can wonder why there's so much distrust of the legal profession. Anyway, so more questions?
Thanks. Yeah, I can ask another, and this is all I'd like to actually ask all our panelists eventually, but so something I think is unique for students who are interested in, and a lot of students are interested in doing their own, starting their own legal company or doing their own practice or whatnot. Something that's unique is we all have some domain knowledge, which is being able to practice law and eventually leverage our domain knowledge to start our companies. So how did you feel comfortable? I know you're still practicing now, but I guess kind of what I want to know is how much. Sorry, I'm trying to.
Good. I have an answer to that.
Okay, yeah. I guess when do we know whether we know enough of? How much time does it take to feel comfortable with the domain knowledge we have? I know it depends on what we end up creating, but I don't know, I'm just trying to get a gauge of.
Yeah, I know what you're saying, I think. First of all, I'm not a full-time practitioner. I run a virtual law firm in Maryland. I'm a member of the bar because I want to still use my own technology. It's really a part-time thing. The major thing that I do is running an entrepreneurial company that provides a service to law firms plus a couple of other things. You can leverage your own domain knowledge into an entrepreneurial venture when you, frankly, you think you're ready to go. Raj is a good person to ask that because he was a patent trademark lawyer, and then he saw another opportunity and leveraged that into trademarking. It's a commercial. So we're running a course on lawyers as entrepreneurs, starting one in the summer, one in September, through Digital Lawyer. This is the commercial. Okay. So I've got a Digital Lawyer. You'll see these course descriptions. It's a one-credit course. And we basically deal all the behaviors of entrepreneurism and also what's happening in our industry. It's really a deep dive into some of the things that I mentioned today because we know that lawyers will begin to entrepreneur other kinds of entities, not just the practice of law, as they begin to deploy their skills in alternative ways because we're in a time of turmoil. We're definitely, and therefore there's opportunity. So when you go to Digital-Lawyer, there's a lot of information. You can sign up for it. You can see there's a lot of content generally. And a set of courses on lawyers and entrepreneurs, legal project management, expert assistant, all the things that I've been talking about today. And on the entrepreneurial side, it's important to be able to understand business models, like I gave you a little bit of a taste of it today, business models, monetization, web enterprises, there are another sets of skills that you really need to launch these enterprises. But we estimated, if you go to AngelPay, there are 400 law-related startups. Many of them won't succeed, but they're startups. And something we estimated in the last quarter that $200 million VC money went into legal startups. So it's becoming an area of real focus. It's one of the last, the travel agency business has changed, the banking business has changed, the brokerage business has changed, healthcare is changing. Legal is one of the last ones that's going to be the target of more radical change in America. And it's coming in your generation, so you need to be prepared for it. That's the end.
All right.
Thank
you.
Thank you very much.
Okay. So I think one of the other interesting things that will inevitably come the more firms are embracing virtual law practice is that sort of information, so legal content will be much more accessible to the end user client when it's now currently sort of packed away in in some file cabinet in the law firms. Individual consumers can at any time sort of call up their contracts and have that accessible through the cloud. And I think that's a trend we're already seeing with corporate departments kind of demanding that kind of access to the legal work product in a real-time basis from the outside law firms. And I think that's coming to sort of end user consumers too, the more virtual law practice we have. So anyway, so Raj, why don't you come up? So our next speaker is Raj Abiyanki. So Raj is a very, very sort of multifaceted innovator and entrepreneur, law and entrepreneur. He's his first degree is actually he's an engineer, and he sort of really comes to the legal system and legal practice with that mindset of an engineer. His first practice for a large patent firm, then opened up his own very successful patent practice, and then actually Fatwa, was that before your patent practice, or sort of in between? So he's also not just an innovator in a legal technology space, but has also started another web company called Fatwa, which is a neighborhood network. There was another version of that was then sold to Google. But I think what I think is most interesting for us to hear Raj talk about is his trademarkia business, and which has been rebranded as LegalForce. So Raj has a tremendous amount of interesting ideas for how you can actually use government data and put sort of a webify government data and make it accessible to consumers and interesting to consumers. And so that was the idea for Trademarkia. And with that platform, these workflows that he created on the Trademarkia website, he's actually been able to consolidate the trademark practice market. So he's become the biggest trademark registrant in the world. Trademarkia gets over 2 million unique visitors every month, and is a really sort of very, very successful business. And Raj didn't stop there. He says, okay, trademark law is interesting, and we've done a great job at consolidating that market. But he's interested in providing using that model for all legal services, and also making accessible, making law accessible to the average consumer. And so he created this LegalForce brand and opened a storefront on Main Street and University Avenue in Palo Alto, opposite the Apple store, and has a law firm basically where consumers can walk in and get legal advice at affordable rates. Really from between 7 in the morning to 9 at night, 7 days a week. So really new kind of concept, and he's a very gutsy entrepreneur and real innovator in the space. So it's really great to have you here with us today. And why don't you take it away?
Thank you. So how many of you are law students, and how many are engineering or computer science students? Just out of curiosity. So how many law students are here? And then how many engineering CS? Yeah. Okay, good. So I'm going to talk about what lawyers, since most of you are lawyers, I'm going to kind of tell you what you can do to play a part in the future of legal informatics and how we went about with building Trademarkia. So the first thing, I think I should do, instead of giving you a presentation, is to give you a tour of Trademarkia and kind of explain how we decided to create this business. So what Trademarkia is the search engine. So when you go on this website, it doesn't say, buy anything. It's not like LegalZoom which says buy something. But there's a big search bar, and you can search something. So you can search Facebook. If you wanted to trademark Facebook, you know, that would be a problem because there's all these other trademarks that exist now that are about Facebook. So you can see whether or not the mark is available prior to applying for trademarking the name. Now, on the other hand, if I typed anything else in, it sends me to a sign-up page where it looks like GoDaddy, and I could apply for a trademark in different regions around the world. So what we've done is we've taken the government data of trademark search, and the very first question that a new entrepreneur wants when they start a business is my name available for trademarking? So we've made that information available in a way that is like a domain search registrar. So we make it very easy to find whether your name is available, and if it's available, you can apply for a trademark all over the world. And what's interesting about that is, you know, to achieve that, we needed to get to scale. And as part of getting to scale, we also decided that, you know, it's really important to have information that is interesting for our first customer. And who do you think our first customer is? Who should be a first customer for any kind of legal startup, in my view? Do you have a guess? In my view, the first customer is the search engines. It's the Googles and it's the Bing, mostly Google, since it's got the larger market share. And so you need to design a website, take data and design it for Google, because ultimately your end customers, if they are accessing you on the web, are accessing you from a search engine. And if they search something that's a phrase that relates to something that they're looking for, you need to be able to be visible on that search result. So part of this is to make sure that you have optimized the data you have so that your first customer, the search engine, is able to index the information you have. And part of that is to understand how do you accelerate the possibility of getting search engines to index your information. So one is to create user-generated content, to let your own users contribute content and grow that way, which is similar to Yelp or sites like that. That's a very long road to go because you don't have any users up front. So how do you accelerate the path of getting enough content that the search engine will find relevant to a particular search query that matches what you're looking for? In my view, there's a huge opportunity for lawyers in that space, because lawyers across the last few hundred years have created all kinds of documents, a lot of writings, and most of these writings aren't indexed in Google. In fact, most of the data that is captured from legal information is not indexed in Google. And so what happens is, why is it not indexed in Google? Because government agencies and courts have no incentive to actually publish legal information out. If I'm the trademark office and someone applies for a trademark, the government doesn't care that Facebook applied for a trademark and let's share it with all the journalists that Facebook applied for a trademark. The trademarkia does. So the opportunity in search engines do, because the way the search engines work is the more sites link back to you with news, then ultimately they think you're a higher reputation site, and they will allow you to rank higher on search results. So I just took an example, Facebook. So this is a Facebook page on Trademarkia. Now if I look here, every trademark of Facebook as a function of time is listed here. So it's kind of like a catalog of a company as a function of time. So I can tell how Facebook started from its first logos to its latest logos. And what's interesting about that, if I'm looking at a company's history, Facebook had a trademark called parakeet. I don't even know what that is. Give your computer the bird. And that related to something interesting that was related to Facebook. And yet it's gone to history. And so we've basically taken a way of organizing government data into a catalog of a corporate life of a company. What's also interesting about that is it also gives me an opportunity to take trademark information and make it information about brands people love. So if I take Facebook, or I take something else, parakeet, and I want to learn more about it, the goods and services description of this trademark is actually related to a service or a product. So in this case, it's a computer software for manipulating data stored on hard drives. This could have easily been a Tesla car. And every single brand that's trademarked is associated with a product or service, which has, in certain products or services, have a brand loyalty to them. And the brand loyalty translates to journalists that will write articles related to that brand. And so what we decided to do is we decided to take the trademark information and make it more than just trademarks, but rather into a brand search engine for brands that people love. So brands that people love, and being able to follow those brands is a function of time. So if I write about Tesla Motors, every journalist that's in America that covers the automotive industry can subscribe to an alert, or we can subscribe to them. We can ask them, do you want to get news about Tesla? Because trademarks are a leading product indicator of upcoming product changes. People either release a product or they'll abandon the product because of their trademark changes. And they'll do that prior to the product actually being released. So we organize this data in a way that's more accessible to the crawlers. It's more accessible in terms of being social, so people can actually do interesting stuff with it. So if you now, what that translates to is a lot of high quality inbound links from people that are looking for brands. So if I were to go to Twitter and I was able to search for Trademarkia, most of the links have nothing to do with Trademarkia. They have things every day, every hour. There's people tweeting about stuff that people find on Trademarkia. They're not talking about Trademarkia. They're talking about random stuff like Charlotte's Web or whatever, but they're linking back to us as a news source. And because of that, we get this high quality inbound link. It changes the organic page rank of our site, and that organic page rank has made us now on 20 million unique pages show up very high on search results. And that's driving a huge amount of traffic to our site, a very small portion of which, so right now there's 70,000 people on our site every day. And to put that in perspective, there's one person on our site every second of the day, 24 hours a day. And a very small number of them will apply for a trademark. But at the same time, when those very small number apply for a trademark, because of the traffic our site is drawn, because we've become a media property, we've drawn traffic to us. Yeah.
Can you perhaps also address a little bit how you use there's a lot of people who look for trademarks just out of general interest, but then there are people who want to actually register a trademark, and you've been able to set up a process where you can, through a law firm, your law firm, actually help people in a very fast way, in a very affordable way, get register trademarks. And we have been outsourcing some of that process to India, and you have some attorneys here. And so traditionally, like a trademark registration has cost like several $1,000s, right? And you have you've been able to create a profitable business, making it available for a couple of $100s and making registration possible for a couple of $100s. So
yeah,
how
I
did
think
you do
that's
that?
a byproduct of our site, though. What happened is, if I was to make a website and say we're outsourcing to India, we're doing things with a globalized structure, no one's going to come to it. So the first thing is, how do we create a technology company that drives a huge amount of traffic to drive the economies of scale necessary for us to then figure out a more optimal delivery chain of services. So if I look at, if I'm filing 3 trademarks, I don't know that I need to have 100 people in India supporting 30 lawyers here. But if I'm filing thousands of trademarks, like this year we'll probably file almost 20,000 trademarks. To put this in perspective, it's about 360,000 trademarks filed in the US every year. So about 6 to 7% of all US trademarks are filed by our law firm. I mean, we protect 1 out of every 20 brands in America. And that is a huge volume. And because of that, then we have this opportunity to make our services chain efficient. Now, that efficiency gain, so I would argue that our price is not the reason we're successful. I could probably pretty much double our price. It's not an elastic kind of model. It has to do with trust. So someone brought up a question about trust. So we've taken information and made the information draw trust. So the biggest success the lawyer has is to build trust with the client. The trademark attorney needs to know with their client that the client's first wants to know, is my trademark available? We've taken that central problem and made that problem transformed through the web. So just like WebMD gives you the answer, we give you the answer, and our service is a byproduct of that. So what's happened is we've gone from having 20 clients, having about 34,000 clients. We're adding 500 clients every month. And unlike LegalZoom, these become clients of our law firm. So we have clients of our law firm and an attorney assigned. So our challenge is to help those clients grow with our law firm and our services. So we've moved from simple trademark filings to doing, right now we're counsel to over 80 different trademark oppositions, which are very large administrative law litigations. We're counsel to 4 or 5 very large trademark and copyright and trade secret litigations as well.
So one thing that I think is also amazing is that this started out in 2009, and you scale. I mean, can you talk about scaling a little bit?
Yeah.
Scaling it?
So the first, the first thing that I could impart to you is how to build a new internet company, right? That can do what we're doing. So the first thing is to identify the right data set. And there's so much data out there that you can take and organize. So you talk about, before this we had lunch about computational informatics. How do you take data, raw data, and transform it to deliver an answer that people, your first customer, which is people searching Google, are likely to search for? And where do you find those pockets of hidden data? In the legal space, they're very easy to identify. So on a federal government level, if you go to data.gov, there's just a tremendous amount of links to other federal agencies where that data is stored. The trademark data is here as well, right? There's just one of thousands of other kinds of data that one could use and leverage to create interesting search experiences. The next question is how do you transform that data to something interesting that your target customer is going to find valuable. And so you look for data that's rapidly changing, where there's lots of data that is going to generate alerts because search engines like this rapidly changing data. Then how do you transform it to meaningful analytics? Your other major source of data in the legal space, which is mostly unindexed, is PaySearch on the federal government level. So how does someone even know that someone is winning a lawsuit or losing a lawsuit? How's even lawyers looking? In fact, it's funny. I'll ask some of our, now we've kind of moved up the stack, and we have a whole bunch of litigators doing complicated stuff that were from large firms. And I asked them, looking at some other case that's not our client, that's still in progress, who's winning and who's losing? Can you tell? It's extremely difficult to tell because there's not enough ways for someone looking from the outside to look at a massive docket history of case documents about what's happening in a meaningful way. So, the problem is taking this data, which is right now largely unavailable to it's very difficult to understand what's going on with that data, and being able to take whoever your customers are and be able to drive meaningful analytics to that data. So this is a federal court system's records, and it's a database which basically can list all the cases of patents and trademarks and any bankruptcy filings, anything else that's related to the legal issues. But you take a complex docket and you look at this docket, even a very skilled lawyer has no idea what the hell is going on in this case, okay? And it's horrible because, why is that? The reason is because computer scientists and lawyers haven't gotten together and figured out a way to make this understandable for anyone other than people billing a bunch of time to figure it out, okay? Because look at this. This is a docket history. Now, how is a lawyer supposed to know who's winning? All I want really is a key performance indicator. This party is doing better than this one. That's what I want to know. And here's the last 3 things that have happened. This is the last motion, and these are the I want to be able to summarize this into a small paragraph. Now I need to hire a lawyer, pay $400, $500 an hour to go through this for maybe 40 hours before I get one quick answer like that. Okay, and this is a real problem. So this is now, in this case, my customer is my lawyer, but it's really my customer's Google, who's going to search for a particular search term that's going to take this data and synthesize it into a set of key performance indicators of an ongoing federal case. So mixing, now a computer science major and an engineering major by themselves can't solve these problems. Why? Because they don't understand what the hell the summons means. They don't know what the difference between summons is or a subpoena. And so as a lawyer, you have an opportunity to translate the law to what the meaningful analytics are that people want, who the customers are that want that information first is a challenge. So I think as new lawyers or new computer science guys, you may not know who wants what information. So part of that is a discovery process. It's interviewing and trying to figure out what the pain points are, right? So talking to lawyers, talking to clients, talking to people that are affected by complex legal issues, if that was your focus, to determine here's the pain point. And then here's the raw data that can be analyzed across these metrics to find the information that you need, and how do you determine that the outcome based upon that. If you look at immigration data, it doesn't have to be lawyer data for complex litigation. It could be immigration data. If I'm immigrating from Milan, Italy to San Francisco, what's my chances of getting my H-1B granted? You know, and I'm an engineer. I mean, is there anything that will tell me that? What's the immigration trends? So every different type of legal industry has a set of core data, which is waiting for smart entrepreneur/lawyers who can work with people other than themselves. Because one of the challenges, lawyers, we get trained to work in one way, computer scientists get trained to work in another way. To bridge the gap across the two and come up as teams in cross-functional ways to figure out solutions to real problems and really do this in context of trying to solve a monetizable opportunity. As a young lawyer or a young engineer, I'd caution you to start a startup that has no revenue model. Make sure you clearly understand your revenue model up front, because if you want to build something that doesn't have a clear revenue model, that's going to require a whole bunch of capital, it's really a long road ahead that you have in the legal space, because of the lack of exits. And because of the lack of exit, the funding is very limited. But if you have a business like what we've built, which has been raised with no venture capital, I don't have any bosses. I generate millions of dollars of revenues every single year that it makes us very profitable. That we can reinvest into our projects that don't necessarily make money. So we've become our own VC, and such as our store. But we've got other things too. But it doesn't matter. I can have a really nice store, or I can have a bigger house in Atherton. I don't necessarily need a bigger house in Atherton. I don't need another car. So the bottom line is, how you choose to invest your profit is your own decision. But if you can consolidate an entire industry, then you don't have to worry about satisfying a venture capitalist. My previous company raised $7 million. I had Norwest Venture Partners, I had Stanford professors as on my board, and it was very difficult to constantly go back to them and tell them, look, we burned $300,000 this month, and revenue, 0. Next month, revenue, 0. Next quarter, revenue. It's a very stressful thing to have to go do that, because their investors have expectations. So in the legal space, it's one of the easiest to monetize if you figure out the solution. Because if you figure out a set of clear problems, create with a clear solution to that problem, and define how you're going to make money with that up front, there's just so many opportunities, because the data is there. The data is not indexed. And what do I mean by index? So if I look at the trademark data, people will tell me, the USPTO for years has had to search for trademarks. You can go to the USPTO website and search for trademarks, right? So sure, you can search for trademarks. But the way that it's searched for trademark isn't the question. The question is whether that data has become social, relevant, and interesting to people. It's just interesting and useful. It's useful, but it's not social, relevant, or interesting. So taking what is a legal concept and make it for the masses, or make it for your audience, it could just be lawyers, but lawyers looking at a huge data set and trying to understand it. I think you had a couple of questions here.
Actually, I had, sorry, so when you started trademark here,
Yeah.
the challenge was the user behavior, because users were not familiar how to search trades online, right? So probably that might be one of the challenges.
The first is to create critical mass of users, and so we wanted to create a media property. So we wanted to create a newspaper of brands. So the way we saw it, we didn't see it as a trademark filing GoDaddy thing. We wanted to create a newspaper of brands. And so how do people track the brands they love? How does Wikipedia know what the original Ronald McDonald looked like? So you have it's related to trademarks, it's related to the protection of brands. So when you look at immigration, what does this mean? This is immigration data, but really it's new Americans that are going to potentially contribute to the economy. And so if you look at what it means to people, you know, in a different way rather than illegal, how do you translate what the legal mechanism for protecting something is to what the value it provides to society, and explain that value in a accessible way, right?
I think Richard had a question.
Yeah. This is another question. So just like computer science need lawyers to explain similar terms, we also need engineers to build out these websites and products. So your last trademark, you say you didn't raise venture funding. Did you have a team in place from before that you're able to build out the
So I'll
site?
tell you the best place to recruit co-founders, okay? The best place to recruit is not Craigslist job posting, or it's not your okay? The best place is to go to Craigslist gigs, okay? Is to go to meetup groups that relate to the subject you want. Craigslist gigs people are usually employed. It's free to post in Craigslist gigs. It costs money to post in the Craigslist job section in the Bay Area. But the gig section is far more effective. Because in my experience, my co-founder for Facto, my co-founder for Trademarkia, I found on Craigslist gigs. And I can tell you the quality of applicant is just much higher. My current new ventures, I pretty much recruit on Craigslist. You want to find people that are employed. Because out of every 1,000 programmers, there's only 1 or 2 that are actually really great, in my view. So the one that's looking for a job is usually not the one that's great. Someone who's got a very proven, someone who went to the best school isn't necessarily the one that's great. The one that's great is the one that has a demonstrable portfolio of work that they've done and can explain to you how that they did that work, how they did that work, and how quickly they can get that work done. And so part of it is to be able to take cross-functional skills and recruit them from the places where people go. Like currently I'm working on a robotics company. This robotics company trying to find co-founders for that and partners for that. There's the Homebrew Robotics Club in Silicon Valley. It's a bunch of people that meet on weekends and they build robots. And they do this because it's fun. And yet, you know, you'd never find them on Craigslist. You need to go there, you need to network with them, you need to be able to speak their language, you need to show genuine interest and inspire. So my last set of slides, I don't know how much time I have. How much time do I have?
Well, maybe 5 more minutes. I think Kartik
Okay.
had a question too. And
Sure.
and then we should take maybe a 5 minutes break before Alma.
Okay.
But
Well, yeah, I was just wondering, the data is on data.gov, but do you scrape that, or?
You don't have to scrape it, because most of the time, the government agencies will publish the feed. So for example, with the trademark data, USPTO made a deal with Google, and so Google publishes the bulk data, right? And there's a bulk data feed that
Because you
Google
probably
publishes.
need that real time, right, so that you can.
At least it's a daily drop. It's a daily drop of FTP
Okay.
data that gets published. So different agencies have different policies.
Yeah.
Some of them are a little more difficult to get at. The Copyright Office, we did a FOIA petition, we got access to it. So a lot of it's not structured well. A lot of the tags and the way it's organized has to be kind of normalized. So there's a lot of effort that has to be done so that you can make sure that it populates and represents the data the way it's supposed to. It's
Yeah,
often a
right.
legacy system.
I just had a quick question. Given that it seems like one of the primary approaches of trademark was to increase traffic, I guess maybe over first improving the efficiency of the product, the legal service offer, which is often trademark legal services. What would you recommend for a new legal startup? I guess the balance between the amount of energy and resources put into just making that brand, improving traffic, getting customers to be able to see your website on Google after typing in a search, versus spending energy and resources making your product or your legal service that you're offering more efficient or better than competitors.
Right, so it's like a funnel, it's like a cart and a horse, right? Do you get the horse or do you get the cart, right? So it depends how hungry you are. If you need to put food on the table, you need to get the horses there before you build the cart. If you have the luxury of supporting yourself and building all the infrastructure and then figuring out how you get customers, that's great. So it depends, right? So it depends on your, in my view, to be a real innovator, you have to first find a way to get access to the client. Now, there gets to be a problem. Like, we went from filing very few trademarks to filing thousands of trademarks. Then it becomes a real operational challenge to scale and not commit malpractice, to make sure everything gets done right, to make sure it gets done efficiently. And there's a whole bunch of stuff I could talk to you about that, right? and getting sure the entire industry that we're disrupting doesn't hate us or doesn't drive us out of business. There's all kinds of challenges there, but those are good problems to have. A lot of people that develop internet sites, for example, they don't realize they have to they have to activate their users, and then the users will adopt their platform, and then addiction. So activate, adopt, addict, right? And so a lean developed methodology, if you think about, oh, once we have all these users, we're going to do all these things, you're thinking 2 steps ahead. You need to take a step back and think what happens when you have no users and no one's coming to your site, and all your dreams about what will happen when there's lots of users never materialize because you never started from that first.
So let me add a quick note to that. So there are all kinds of legal startups. You can have the B2B where you're selling to lawyers who's doing B2C. We have a taxonomy of all the different kinds of legal startups. So I think I'll send it to you. Maybe you might want to circulate it. The hardest thing to do is what he did, is B2C. Normally it requires a lot of capital. You need to understand that I think it's exceptional. That this venture and how it's come about. The hardest thing to do is B2C. Usually you need a lot of capital to do it. And the capital acquisition. And if you can be really creative and innovative and totally unique, you achieve this. There are all kinds of startups. If you're doing B2B, your marketing methods are different. If you're selling to lawyers, you use different methods to do that. We sell to lawyers. It's a wholly different environment. It's a narrowcast rather than broadcast. Anyway.
A couple of questions.
Yeah.
I can wait or you can.
I wanted, because think about this, your lecture and the previous one we heard about Let's National, that basically are visualizing information, public information. Whether that was patents, you're doing trademark. Do you have any ideas of successes when it comes to information that is blocked, like law firms that we heard previously in the lecture, that you cannot access that information anyhow easily, and you need some software that will allow you to crawl the robot more easily?
Yeah, I mean, there's legal screen scraping and illegal screen scraping are 2 different things, right? If you're hacking into some site to scrape it, that's one thing. If you're scraping the Copyright Office, which is supposed to be free and provided to the public in accessible ways, but it's not, it's a totally different problem. They're only afraid of getting their servers put down because there's too many people accessing their site. But there's nothing they can do because that data is supposed to be free to the public. On the other hand, there's certain kinds of public data which is free to the public, like Pacer data, which that guy, I don't know, committed suicide over, right? Because he screen scraped a whole bunch of data, but the government was selling that data. Should they be selling that data? I don't know. But that's a revenue-making thing for the government. There's a whole bunch of stuff that is possible, but you don't necessarily, because duplicate content is the biggest challenge. When you screen scrape publicly accessible data, if I took a screen scrape, if I wrote a little scraper and I scraped Wikipedia, and I created Raj's Wikipedia, first of all, no one would read it. And why would no one read it? Because no one will find it. Because Google crawl, the algorithm that Google has today, will look for duplicate content and see that I've just basically scraped Wikipedia. And they'll penalize me and put me on page 5,000, and no one will ever click on it. Right? So, so you want to avoid duplicate content. And screen scraping will often lead to those types of penalties with research.
So this question kind of came up previously, but I'm just curious because you had substantive knowledge before you went into this. Did the idea for trademarking develop out of the substantive knowledge you had, out of the just frustration you saw among, as a combination of substantive knowledge and the network you had in a legal field, or just I spotted a good opportunity and had I been in the IP space or not?
Well, it started because I wanted to stop being a lawyer. I really got tired of being a lawyer. I didn't like it. I worked at a big firm where my door was closed and I billed time all day and I had this huge salary, but I really felt like a rat in a cage going crazy. So I had to get out of that, right? So I had to get out of that, and I said, look, I don't want to do this anymore. But I like programming, I like databases, this is the stuff I actually like, okay? So how do I take government data and make it interesting? So my first venture was still very similar in an architecture way to trademarking. It had nothing, it was a social network for neighborhoods. It had nothing to do with legal information. Now I decided, well, that problem with that venture was the VC's, expectations compared to revenue. So I said, well, how do I actually win that game if I have these certain skills, and yet I also have these other legal skills? How do I marry the two and have less competition? Because there's very few lawyers that understand how to do database. But more so, even if you're not one of those people, there's no reason you can't be. So part of it is your willingness to learn. So one of the biggest things you should know is how do you actually not preclude yourself to a certain typecast. You know, I'm a lawyer, so this is what I do. No, you want to be able, you're a lawyer, so you can do anything. You want to think like a child. A child thinks they can do anything. You don't want to lose that, because if you lose that, all of a sudden you start growing. And if you start growing, to me, that's, you know, a horrible thing. But as an entrepreneur, someone that wants to cross the boundaries of different disciplines, you have to be able to think at a deeper level and not be afraid. And part of that is not being afraid to know you don't know something, and then spend the time as you do in school to pick up books and learn, right? Or talk to people that know and learn.
That's great.
All right, on that note, thank you very much. Both Raj and Richard are going to be speakers at our Future Law Conference tomorrow. I hope you're all coming to that. And if you haven't, you should register. You know, class code is class 2, so that's going to get you registered for free. So please come. So let's take a 5 minutes break, and then we'll hear from Alma in Allegory.
We should get water. Yeah, you change that.
Hey. How are you? Oh, man. Doing okay. Running all over the place. How you doing?
I'm okay. I'm a little frazzled today. I got my first trekking ticket.
Oh, bummer. First, God, if I had $1 for every parking ticket I had, I'd be a much richer person.
I told my mom, like, don't get started. She was like, you're the only one of all of your friends who hadn't done it yet.
You know you can appeal them, right?
Really?
I've done it successfully before. I might be the only person in history to actually have appealed it and gotten it. I've appealed it numerous times, only once did it actually work.
Oh, okay.
But I blamed it on, like, people were moving in and out, and my car was parked in a lot that shouldn't have been, but it was like a holiday, you know, like I created this little narrative.
Today's
Of course, we don't know.
but it's
Ask a
okay.
lot of money for that. And ask money at the same time, find a way to make it faster and easier to access. And this is well, information is unaccessible. How can we because we know law? They have made way.
I don't know.
Companies do the same thing.
I don't know what you're doing. I mean, so like it sounds like there's you feel like someone is asking questions and someone is answering those questions, right? You're matching the two, right?
Portion of it, the whole idea is the one you just described. Someone is coming to what options they have. It should be an option
Go for a walk.
so how do you make them access to they can manage?
Yeah, this one's
Right, so first you want to see what is it that normally happens in the process. What is the process today?
So
You might not.
To get that
this
question.
is still next week.
It's part of the test.
So the student that wants to know, right?
I think they
comes back and saying
That's true, I guess, identify, like, here's the
Which is something that's going to be interesting, because depending on how specific the tags get, tags are going to be more specific area of law. Right, standards is a huge, broad category, but it needs to be very specific.
So I think it's statistics. So one thing is, if you can take a statistical approach,
Now no longer.
and if you take historical trends, and if you get the data about what the chances are, and give people a statistical probability, they'll trust you. Suppose you said, okay, here's my general drop down something, and then it gives you an answer based upon some data about what the person is.
I know what you
So first is what kinds of baseline, how do you build your baseline data, right? But baseline data, here's what I built a number of ways. One is through public data, one is second is through surveys. And you ask them about how they can. And you model a database with ongoing analysis of probability. And then the key thing there is tied to the super. If you get
some sort of satisfaction. Once you feels happy, getting the actual answer is something that predicted. And then when I get a more accurate answer, how do you then translate that initial prognosis to service
technologies, right? You have suddenly not just probably you have been crawling for years, but the understanding that you can use them to actually do computer algorithms that are not automated. And I saw this exact when you actually have that giving you answers on who winning cases, and now I thought it would be amazing that this information with stock exchanges which trigger them to want to know this. And it's also public access. You can say, well, maybe winning a case or losing a case is actually changes in the market. But
yes, no, I do want to include like some subjectives. But as far as
yeah,
like you think it's the root of like
that started reordering search.
Yeah, at least the baseline.
And Google came out with Nexus 1. They trademarked Nexus 1 as a mobile phone. And no one knew Google was going to mobile phone. So it showed up on trademark. CNN and all the major. And they weren't talking about us. They were talking about Google is coming out with Nexus 1 according to the website trademark. So all of a sudden we had all and this happens on a regular basis. So now on a daily basis, some random news somewhere you get cited as a source for it. And because of that, it's just we've become like a newspaper program. No, that was the intention. We tried to figure out organic strategies that would drive high user engagement. So we started with the thesis that we wanted to create something that would drive high consumer engagement and mass consumer. So
you would just like an algorithm, check. You would build it for the page and say, okay, what is it like this?
So there's a lot of data that sort of
and then
government
you take the
people that has
and it would give you a chance to look at
what do people do for entertainment? So you start with like what do people do for entertainment, right? Because there's a lot of people who are not not all brands, but a subset of brands are loyal. So we took that approach. So what do people do for entertainment? Right? Because most of the time people
that's not sorry, that's not the same follow through on thread.
and then we have a site that focuses on that. But then have some angle that some things like
We're doing
just like SF Giants, Nokia history of the SF Giants, enormous. That means losing someone that's loyal to the brand, good interest, and so it's more likely that you potentially go on to protect the brand. And therefore,
We'd only look like
As much as possible. That's why you
We give it. Yeah, yes, it's been a tough start.
I went and like looked at it like you excited about what
Yes, yeah, I drove myself right.
Yes. take
Not real?
starting there's like a life cycle where the business different starts to get a domain, then incorporate it as a trademark. That means the domain and registered trademark and incorporate. And from there, 95% of businesses fail in the first year. There's like a life cycle of bankruptcy, and then there's 5% that succeed or survive and go on. So
You want to make it to one and then one
And then so you go on 30 iterations. So I have a house and a seaside water color, rosemary beads,
All right. So, well, thanks for reminding me. I actually didn't just pass it. Okay, so our next speaker is Alma Assay. So Alma is the founder CEO of a company called Allegory Law. So she's one of the more recent entrants to the legal tech community, and Allegory Law is actually a technology for litigators. And we talk about the Susskind spectrum from bespoke legal services to the systematized and commoditized legal services. There has always been this kind of assumption in the community that providing technology for litigators, or helping litigators be more efficient is kind of doesn't fit litigation practice, right? And we have Alma, who's kind of proving the world that litigation can actually be done more effectively, and you can use technology to unleash a lot of unleash a lot of efficiencies in litigation. And so Alma comes from also from like a big law practice background. She's working for Gibson, Dunn and Crutcher in New York, handling really large litigations, mostly kind of media company related litigation. And some of those litigations they go on for many years, and it's like like Raj showed us that Pacer docket, so like you can imagine sort of the amount of information that's contained in all these documents. And so Alma, came up with her own, cobbled up her own kind of solution using spreadsheets and some other simple techniques to make it more easy, to make it easier to access important information about a particular litigation. And then at some point figured, we could actually make this even better and create a real, solution for that, a real technology solution for that, and has started Allegory Law, and that's a company that started about 2 or 3 years ago in New York, and then more recently, packed up everything in New York, bought a car, drove across country to Palo Alto. Because you heard about Codex.
Oh, yeah.
So anyway, so Alma's here today, and so please.
Thanks, Roland. You saved my voice. Can you do my intro for all of these? That's awesome. Nice to see all of you guys. As Roland mentioned, I was a big law litigator. I worked at Gibson Dunn for 6.5 years. I worked with primarily with a partner named Oren Snyder, who's one of these very well-known litigation partners, trial lawyers, named to all sorts of top 10 commercial litigator lists. For whatever reason, really liked working with me when I was a junior associate. So I started working with him as a first year. He would say things like, I need to see every document in the case. Not 10 hot documents, I need to see every document in the case. And I'm sitting there, just started thinking, well, I can't say no, but if I bring 50 binders of documents in here, he's going to kick me out of the room. So, as Roland mentioned, I started working with spreadsheets. I was ahead of the curve on tech as a lawyer because I took computer science in high school, which meant that I learned how to use Excel, PowerPoint, and Word. So I talk with a lot of CIOs and CTOs of law firms, and they say, yeah, if you know how to use Excel, you are the tech person on the litigation team. And it's very true. So I started just, I still have a vision in my mind of when I started creating my first Excel spreadsheet and just digesting a stack of documents in this case. And Oren would ask from time to time, what are you working on? What are you working on? What are you doing? What are you doing? And I'm like, just wait, just wait. And then one day I walked in with a spreadsheet printed out, nice spiral bound, double-sided, the whole case, this big, and he carried that thing around with him for the rest of the case. And he had me make them for the client, had me make them for everybody on the team. And from there on each new case that we kind of iterated on that and made it more robust and tracked where not just what was relevant in the documents themselves, but where documents were being used. And we were very fortunate to work with clients who understood the value of what we were doing and were willing to pay the upfront cost, which was very manual, obviously, to create these robust digests of our entire case. And what I started to see happening is we would go into depositions and people would throw curveballs. They would put in a document that this witness's name wasn't on, we didn't expect at that deposition. And the typical thing you do there is you're frantically emailing your team back at the office saying, go look through all the other transcripts, where has this document been used, what did everyone else say about it? And you have a whole team and you're hoping they get you an answer fast enough that you can, ask for a bathroom break and prep your witness in the right way. For us, we had the whole case right there, so we could just look up the document and look right there where it had been used, what people had said about it, and we were ready to go. The other thing that I saw was a lot of teams would bifurcate the case. So there was just so much information that they would have one partner in charge of liability, one partner in charge of damages. They would come into depositions and the liability partner would be asking our witnesses questions that were going to kill them on damages. And we would sit there just thinking, what are they doing? Whereas we had 20-person teams who knew the whole case. The first thing you had to do when you came onto our case was you had to, not read in depth, but you had to at least get a copy of what we call the chronology and skim through it and get an idea of all the evidence in the case so that you knew what was going on. At some point, I started having ideas of how we could automate some of this. I had seen the methods work. I knew that they worked, but I thought it is ridiculous that we sit there and have a team typing out the relevant portions and manually logging where these documents are being used. And I looked, and there just wasn't a solution out there for what we needed. So I had an idea. I had no idea how to meet developers. Around the same time was about when they started talking to me about partnership and if you want to become partner, and told me I had an opportunity to become partner, here are the things you're going to need to do over the next 2 years. And I had rushed through school and gotten to this point, and I was walking down the hall one day and I thought, if I'm ever going to try something different, it has to be right now, because I can always leave and then come back and do that last 2-year period before you're up for partner. Whereas if I was going to go all in on those 2 years, at that point I wasn't going to wake up and say, oh, now I'm going to go try something different. So I had a lot of ideas of what I might do, but ultimately a friend put me in touch with some developers and we started I started mapping out my ideas, and they got excited about the legal market. And I told them then, I said, this was 2.5 years ago, I said, this is going to happen. It's not like I'm the only one who's going to think of this. This is going to happen. The question is whether we do it now and lead the pack, or someone else does it later. And so we started working together and coming up with Allegory, which is what you see. So this is Allegory. We're hosted. It's a SaaS solution, and we don't have an app yet. Would love to build an app, obviously, but it is accessible from any mobile device, and the user interface is optimized to work on mobile devices. So this is the dashboard, and I've kind of got my spiel, but if you guys have questions as I go along, feel free to interrupt. I trust that you guys know enough about litigation that I'm going to use litigation terms. So this is the dashboard. It's the only page unique to a given user. It lists all of their cases, all of the events coming up in the cases, consolidated. A lot of this, yeah.
But not everyone's going to know about sort of litigation terms of art and so on. Because we have some computer science
I'll
students,
pull
so
it back.
they
I'll
like
pull it back. All right, no problem. A lot of what you see in here is going to seem really basic, but that's how bad the technology is. That, for example, we didn't have a case calendar. We had an assistant who would circulate an updated PDF every night if we were in trial or in a busy period. Every time that I needed a case caption, and I tell this story to lawyers all the time, and they all nod their heads, if I needed a case caption, I'm searching around my desk for a draft brief somewhere with the case caption on it every single time. So those are just 2 examples, but when you see some basic stuff in here, it is kind of revolutionary in terms of everyone having access to that information at their fingertips. So once I jump into a case, it's universal across the case team here. So one person makes updates and everyone's going to benefit from that. A lot of what we've done in here is also targeted at helping junior associates and, for example, law students who don't know how to manage a case. And very often you start at a law firm and you're thrown a complaint and told, hey, you're on this case, go. And you have no idea what to do. So maybe you create a folder called complaint. Well, that's kind of silly because there's only one document that's going in there. But no one teaches you any of this. And so we tried to do things where you can come on here and we're shoehorning you into best practices for managing your litigation. So for example here, once you choose your jurisdiction, you'll get a list of judges. You can come down, fill out basic case information, contact information, so that now all that information is right here on the front page. And we've had people tell us, you had me at home page, because just having it all right there is that cool. We also automatically populate links to all the rules applicable to the case based on the jurisdiction and judge. So very often junior associates had no idea that each judge has their own individual rules until 5 minutes before filing, and the partner says, you check the judge's rules, right? And they're like, what? So here, again, trying to help them out, you fill out the jurisdiction judge, and we'll give you those links so you know you should read those. Over here, we have all the events coming up in this case. You can add events here. So let's say that you want to add a hearing, but then later you can come in and edit it to make a note as to the outcome. And both when you add an update, you can send a notice to all the attorneys, staff, or clients on the case, so very easily they'll get an email letting them know that this has been added or that what the decision was. All of that goes into a case-specific calendar. So I already gave the example of the circulated PDF. We also very often had junior associates who didn't know that a big meeting was coming up. Sorry, go ahead.
Finish your sentence, then
Oh.
I'll ask you a question.
We very often had junior associates who didn't know that a big meeting was coming up, even though they would be the ones at 8 p.m. the night before who would be asked, hey, you prepared for that meeting, right? So this is a place where everybody on the team can get a bird's eye view of what's coming up on the case, whether they're attending or not, so that they know what they need to prepare.
So I was going to ask if you can link, because I saw it was Judge Cote, and then, as you know, in New York Southern District, the judges are likely to have handled packages of cases that look similar. So can you link to other cases like this case that Judge Cote might have decided? She might have decided a procedural motion in a particular way, and that's useful information in terms of the strategy?
At some point, yes. So one of the very cool things, which probably some of you can guess, and more so when we go into other parts of the program, one of the visions for this down the line, there's no point in doing this now because you need the information in there first, is to enable firms to be able to search across their cases based on structured data rather than trying to scrape unstructured data. And not having to put in the data, but just by using Allegory to do their case, that data is already there. So for example, things such as the filed date, the summary judgment date, and the judge name. So now I can run a search across all my cases and look, okay, how long does it take to get from complaint to summary judgment before that judge? Or judge's name and maybe type of case, and look for other cases in my firm before that judge. So rather than sending an RFI to my entire firm, I can start being able to run those kinds of searches. But right now, we don't link all of that up.
Some of that more generalized data, are you going to plan to share that, or is there a way to share that across firms? So one firm can share with another and say, we want to, that type of, how long does it take to get to someone?
Yeah, we have plans for that. And how to differentiate the data in terms of how you're sharing and not sharing. Yeah?
Does it like ever prompt you kind of for next steps? Like, let's say you uploaded like the complaint and you're on the defendant side, would ever say like, oh, you should probably, you know, fill in when the answer is due, and then we'll send you a reminder or something.
Right now, we don't do that. My objection to auto due dates is that they're very misleading. Very often the due dates are changed or, you know, subject to a judge's individual rules, and so there's a lot of complication there. I think at some point we probably would start to add in those things, but at this point for kind of version 1, the hurdles to make sure to do that the right way were a little bit big versus the benefit that we're getting as an addition to this.
Well, does it like, but I mean like, will it like prompt you like next steps? I'm just thinking like, as, you know, when I go to practice law, you know, I'm a new associate, and like I won't always know like when the next kind of type of thing you have to do is, you know, would it kind of give you like even if it doesn't tell you the deadline, would it kind of tell you like what is like the next step usually, or?
Not in that way. As we walk through, you might see, for example, if you upload opening papers, it'll tell you, hey, here's where your opposition and reply papers are going to go. For a complaint, you know, you see a thing for answer, but we don't, you know, do little pop-ups or instructions like that. We generally trust that, at least in that respect, there's someone on the case who knows, oh, now we need to prepare the answer.
How does this relate to underlying e-discovery evidentiary documents?
So let me just pop to the next page and I'll answer that. So now we're going into the chronology. Typically when people think of their produced documents, they think of e-discovery platforms. So relativity, concordance, summation. We are not fighting with them. We are not competing with them. I have no interest in entering that space. But if you go to their websites, they say they're end-to-end, and their end is production. What that means is they've now put 10,000 relevant documents in my lap and said, good luck. So when I would look at them and say, well, now what? The answers were, well, don't you have a system for that? Okay, well, that was Excel and shared drives. Or, oh, just load it back up into our program, you know, your production, their production, and you can use ringtail, relativity, whatever it is, to use those documents going forward. Those programs aren't designed for witness work, depositions, trial. On their websites, you generally won't even find those words.
So that's a whole industry, e-discovery industry. That's what
right. Sorry. So e-discovery productions are what is relevant to a particular case. So when a case is filed, each side is required to pull together all of the materials that are relevant to the dispute so that they can give them to the other side, which is called production, so that everyone's on the same playing field with respect to the evidence in that case. So that's the discovery process, and it usually starts in a big litigation with going in and scooping out millions of documents from a corporation, running algorithms through them, trying to tag them as to what's relevant or not relevant to this dispute, but really the goal of that is what is relevant.
And right, so just to clarify, so that's been traditionally, like up until maybe 10 years ago, been handled this process by, you know, associates, junior associates, who were going through into warehouses, going through boxes of documents to try to produce the relevant documents. And then we had the starting of the e-discovery industry, like, you know, maybe, I don't know, 10, 15 years ago, and the point you just made is like there are all these technology companies now that, you know, help you, you know, in this process of e-discovery, but then they just dump all this information on the associates, and
they say this is what's relevant.
Yeah.
And so now I'm supposed to work with that evidence and know what to use for depositions and meeting with witnesses and preparing motions, and none of those technologies were designed for that. So here we have our what we call the chronology, which people who worked with me at Gibson, when they started using Allegory, they looked at it and said, oh, it's the chronology. And it is. It's basically what we did in Excel, but made prettier and automated. We have two ways of getting documents into the system. The first is what we call manual, and that is the client has thrown PDFs, email files, video files, anything at you on day one. Well, at that point, I don't even have any discovery vendor, but I need to start working with those materials to form my complaint, to prepare a motion to dismiss. So I can go ahead and throw those in here. They will go into the chronology, so I have a place to start right away. The other option is what we call automatic. That is, okay, now you've used an e-discovery vendor, you've gotten down to what is relevant to your case, your production, and the firm can actually itself add the load files here, which contain all the data for the relevant documents, and then on the next page, drag and drop all those relevant documents in from that same CD. So they're able to just go. They don't have to call us, they don't have to send us a CD, they can just jump in and do what they need to do. So I'm going to jump into a binder of documents here. So this is somewhat similar in parts to an e-discovery program with the basic information. We dedupe everything when it comes in, but something we do that's unique because we are trying to create a working platform, not just streamline to what's relevant, is we allow users to manually dedupe. So let's say that you've added a document on day one, you've done a whole lot of work on it, and now 6 months later you have the produced version, which has what's called a bait stamp on it, which is a tracking number for each page produced in a litigation. Very often now, people just kind of start over because now they have the bait summered version. Well, it's the same document you've been working with since day one, so you can dedupe that against the original here and keep all of your work product, and that would just be listed as another version here. As you scroll over, you'll start to see how this is a little more focused on what's important, how the documents are being used. So we have things like key text, which I'll show you in a minute how that's pulled, notes, any issues, everywhere the document appears in a binder, and then everywhere the document's been used as an exhibit in the case. And I'll show you in a second how those cross-references are created. We let users edit their binders in here as well. So they can come in here, I can go into binder edit, I can add documents that aren't in the binder, I can subtract documents that are, I can also reorder my binder in here. This is all stuff that when I was practicing, I would do by hand and then send a long email to the paralegal explaining exactly how I wanted my binder. So now I can just come in, reorder it, I can print the binder in the order that I want, and that creates a link up here that anybody on the case can now download this binder exactly how I want it. It'll download the binder with all of the documents and companion pages with that attorney added information, so that for people who are tied to hard copy, it all comes out of the system in a way that the copy center can just print it like that. So I'm going to jump into a document here. So this is our document view. You can also come into this through a binder so that you're just scrolling through the documents in a specific binder. You're going to, again, have all your versions here where it's been used as an exhibit. You can start typing and notice all the tags. You can create a new tag just by hitting enter and it'll become a part of that drop down. One of the things we really try to do is keep attorneys doing the things that they're already familiar with doing, not trying to create hurdles to them jumping on and understanding what they need to do. So here, for example, they can highlight the document and that text will automatically extract here and in the chronology. So now they have a running digest of their case in the chronology simply by highlighting their documents, which is something that they're doing anyway. We also have notes here that you can be added or updated here and in the chronology and update in both. Our depositions page links information from various pages so that if I'm in depo mode, all the information I need is right here in cross-reference. This is also where I add my transcripts. And identify exhibits. So rather than upload the same document 20 different times to 20 different folders every time it's used as an exhibit, we cross-reference everything. So you talked about duplicate data. One of you talked about duplicate data. Even within our system, we try to make sure that things only go in once, and then they're just cross-referenced from that moment forward. So kind of like putting a phone number into your smartphone, it becomes available through 20 different applications every way that it's relevant. Here, if they know the document number, they can put it in. If not, they can look it up right here by Bates number, subject line, word search, whatever in the transcripts lets them know what the document is. So then we have our list of exhibits, and that's how those cross-references are created, telling me that tab 90 was exhibit 1 to this deposition. In the transcript, we have the exhibits here. Just like you can highlight key text in a document, you can highlight key text in a transcript, and then you can link that text to one or more exhibits. So now when I jump back to that document and go to the testimony tab, you're going to see all the testimony in the case about that document. So now you don't have teams of attorneys going back through transcripts, looking over and over where documents were used and what people said about them every time an issue comes up, because at any time anyone, even the partner on the case, can pull up a document and immediately see where it's been used and what people have said about it. Our binders page just lists the binders that we were jumping between before. We use indexes throughout the system, so you can search by whatever comes to mind. If all I know is I created the binder, I put my name in. Yeah. Oh, go ahead.
So, you know, the three of our speakers today, you're actually the only one who's actually created technology that needs to be sold to sort of more traditional law firms. Right?
We sell document automation technology.
Oh, okay. So I take that back then. But I thought, you know, it might be interesting to hear you talk a little bit about that process, trying to get that adoption of the technology. I mean, it seems like the technology should be selling itself because it's
no
taking
technology sells itself.
Right. But if you could just, you know, because we have kind of 2 more minutes or so.
Yeah, sure.
And I don't know if there's
That was the same question I had.
That was
Just what
okay.
the pushback
Oh,
was.
sorry.
Yeah.
Training and education, how do you train people? It's related
Right.
to the adoption issue.
So, in terms of law firms, as many of you probably know, there's not a standard sales model for a law firm. And it's something that when I talk to professional investors, it's one of the things that scares them off about the legal space, because it is the old school sales model. You have to go in, you have to get to know the firm, you have to get to know how that firm works. In some firms, you do not want to cross the CIO, CTO, you need them on your side. In some firms, getting put in touch with the tech department is the kiss of death, and you need to avoid them at all costs, and you need to get the attorneys on your side, and you can come in on a case-by-case basis. So it's very different at each firm, and I think, you know, that would have scared me and would be more of a hurdle than it is had I not worked at a law firm and understood that that's just kind of the way it is, and that it is different, but that it still can be done. So I've spent a lot of time just meeting with law firms, and very often the first person I meet at a law firm isn't the decision maker, but they kind of guide me to the right people and give me information that I need. And it's also helped a lot that I was a lawyer, and I've been told, I met with the managing partner of one big law firm, and he said, it's great, you speak like a lawyer, you don't speak like a salesperson, you don't speak tech. I'm like, yeah, well, I was a lawyer. So that has helped tremendously in terms of getting my foot in the door. And then, what was the second part of that? Oh, training.
Yeah, how do you deal with training the team, the paralegals and lawyers that work with the system? What's the story?
So, as you can see, one of our overriding goals was to make it as user-friendly as possible, use language familiar to lawyers and paralegals, enable them, if they don't want to be trained, to just jump on and go, which very often is the case. But we do come in and do a training session. It doesn't take long. I mean, I was almost through the entire program. It's not so robust with features that it's bogged down and so complicated people can't use it. And then we have a litigation technology consultant who looked over, when I started putting together our manual, he looked over it and he redid the whole thing in a manual format. You know, lots of words, and I emailed him back and I was like, no. No attorney is ever going to read a manual. So what we have is more of a quick sheet, quick guide. Imagine a camera manual where it's got circles, lines, this is what this is. And that way it can just sit right next to them and look like what's on the screen.
One other quick question. This is a litigation case management solution, you would say, right?
Well, so people hear case management and they think of practice management solutions.
No, litigation management.
So I call it litigation management.
Right. Do you have any competition in this space for this particular kind of application? Who's the competition on that in this space? Anybody do anything like this? I'm just curious.
Not to my knowledge. The tool that people most often bring up is CaseMap by Lexis.
CaseMap.
So these are kind of the categories: e-discovery, case firm administration, which really is calendar, contacts, billing, timekeeping for small firms. And then case evidence analysis is the one that would be closest. So people often bring up CaseMap. The analogy that I've used that's worked really well is if CaseMap is a rotary phone, sure, we're both phones and we're a smartphone. So you can, it's basically a more complicated version of Excel. And very often I speak with attorneys and they say, yeah, I don't know how to use case map, I just use Excel because who knows how to use that. So it is very manual, and it's not linking to everything else. It does the post-production aspect, but it's not then looking at how you're using those documents and where they're being used in the case.
Well, on that note, we're pretty much at the end of our time. Thank you so much. Okay, so next week we'll be talking about access to justice and technology and access to justice content. We're going to have Bonnie Huff, actually, from the Center for Families, Children, and Courts come to us. She's one of the leading thinkers in the access to justice space. And also Catherine Alternator from the Self-Represented Litigation Network. So it should be an interesting session too. And again, tomorrow is the conference, so hope to see you there.
You going to this conference? I gotta bounce for